All right, we've made it through 6 sections. Now we're into section 7. These are remedies. So section 7A, cure period. A party shall have an opportunity to cure a potential breach of this contract. If a party fails to comply with any provision of this contract, the other party shall deliver a notice to the non-complying party specifying the non-compliance. If the non-compliance is not cured within 3 days after delivery of such notice, the cure period, the failure to comply shall become a breach of contract. If escrow company or recorder's office is closed on the last day of the cure period and close of escrow must occur to cure a potential breach, close of escrow shall occur on the next day that both are open for business. 7B, breach. In the event of a breach of contract, the non-breaching party may cancel this contract and or proceed against the breaching party in any claim or remedy that the non-breaching party may have in law or equity, subject to the alternative dispute resolution obligations set forth herein. In the case of the seller, because it would be difficult to fix actual damages in the event of buyer's breach, the earnest money may be deemed a reasonable estimate of damages, and the seller may, at seller's option, accept the earnest money as seller's sole right to damages, and in the event of buyer's breach arising from buyer's failure to deliver the notice required by Section 2B, or buyer's inability to obtain loan approval due to the waiver of appraisal contingency pursuant to Section 2L, the seller shall exercise this option and accept the earnest money as seller's sole right to damages. An unfulfilled contingency is not a breach of contract. The parties expressly agree that in the failure of any party to comply with the terms and conditions of Section 1D to allow close of escrow to occur on the close of escrow date, if not cured after a cure notice is delivered pursuant to Section 7A, will constitute a material breach of this contract, rendering the contract subject to cancellation. Okay, the alternative dispute resolution. Buyer and seller agree to mediate any dispute or claim arising out of relating to this contract in accordance with Realtor's dispute resolution system, or as otherwise agreed. All mediation costs shall be paid equally by the parties. In the event that the mediation does not resolve all disputes or claims, the unresolved disputes or claims shall be submitted for binding arbitration. In such an event, the parties shall agree upon an arbitrator and cooperate in the scheduling of an arbitration hearing. If the parties are unable to agree on an arbitrator, the dispute shall be submitted to the American Arbitration Association in accordance with the AAA arbitration rules for the real estate industry. The decision of the arbitrator shall be final and non-appealable. Judgment on the award rendered by the arbitrator may be entered in any court of competent jurisdiction. Notwithstanding the foregoing, either party may opt out of a binding arbitration within 30 days after the conclusion of the mediation conference by notice to the other, and in such event, either party shall have the right to resort to any court action. Exclusions from ADR. The following matters are excluded from the requirement for ADR hereunder. 1. Any action brought in the small claims division of an Arizona Justice Court, up to $3,500, so long as the matter is not thereafter transferred or removed from the small claims division. 2. Judicial or non-judicial foreclosure or other actions or proceedings to enforce a deed of trust, mortgage, or agreement for sale. 3. Any unlawful entry or detainer action. 4. The filing or enforcement of a mechanic's lien. Or 5. Any matter that is within the jurisdiction of a probate court. Further, the filing of a judicial action to enable the recording of a notice of pending action or order of attachment, receivership, injunction, or other provisional remedies shall not constitute a waiver of the obligation to submit the claim to ADR, nor shall such action constitute a breach of the duty to mediate or arbitrate. Attorney's costs and fees. The prevailing party in any dispute or claim between the buyer and seller arising out of or relating to this contract shall be awarded their reasonable attorney fees and costs. Costs shall include, without limitation, attorney's fees, expert witness fees, fees paid to investigators, and arbitration costs. Okay, that's section 7, and those are the remedies.